Hey folks, welcome back to the Law and Crime Network. I'm Michel Bryant with you for the afternoon session, joined with Daniel Liebersohn, trial attorney, and Sanford Rubenstein, criminal defense attorney, civil rights attorney. We've got a lot to talk about, but right now we are in not one, but two trials live at the same time today. We are coast to coast, gavel to gavel. We've been following the Florida case against Scott Nelson. We are going to go now to Texas. This is the case against Wesley Mathews. This is a bizarre scenario procedurally, if nothing else. This man is accused of and has effectively pled to causing the death of 3-year-old Sharon Mathews, his adopted daughter. So there it is. That's the very beginning of this case we're just starting to follow in Texas against Wesley Mathews. If you just tuned in, you're thinking, oh, I missed the whole trial. Where to go? Because now we're doing the penalty phase. Not exactly. We're going to have to take a step back and give you an idea where we are and how unusual this is. And luckily, I've got some guests here to help me figure this out. This case, as of late last week, was going to trial in front of a jury on murder. This is a gentleman accused of, as you just heard from those opening statements, of killing his 3-year-old adopted daughter because she didn't drink her milk, ostensibly. And then dumping the body, and they didn't find it for 3 weeks. It was difficult to tell exactly what the cause of death was. The murder was never a death penalty case from the beginning, making it pretty clear the prosecution figured that was going to be a reach. So now, last week, they come to what's called a slow plea in Texas, where they've effectively had this defendant plead guilty to the charge of injury to a child by omission. Now, this jury is going to hear all the dirt, all of this case, all of the nasty details, purely to come up with a punishment for this guy. Could it be life in prison? Could it be probation? Believe me, they're going to be putting enough stuff on. Probation, I think, is probably highly unlikely. With me once again to help understand what's going on here, Daniel Liebersohn and Sanford Rubenstein. Sir, let's start with you, Ruben. Stanford. This is unusual, this slow plea. Are you familiar with this anywhere other than Texas?
Actually, I'm not. But what's really interesting is the fascination with the strategy of the defense. Instead of trying the case on the issue of guilt or innocence, they're saying, okay, he was guilty, but not what you want to charge him with. Guilty of an act by omission. And now you can see their strategy with this jury who's going to decide probation or life. Quite a big span. Maybe that strategy was very, very smart. We'll know once this jury comes back.
As these details unfold, I'm sure we're going to see how the jury reacts, because I think it's going to be outrageous, and it's going to be difficult for the defense, Dan, to just say, give him a slap on the wrist. Let's let him off the hook. What do you think?
I agree with you. It's a very traumatic case, very emotional case. I agree with Mr. Rubenstein about the strategy. What we see here is a lawyer that wants to focus more attention on the good of his client. He used the word accountability many times. What he wants to show is that the defendant is not here to waste the jury's time. He's not here to push the process to its great limit and try to somehow get a not guilty verdict when that might not be appropriate. He wants to concentrate on his client, who looks excellent in the courtroom, who wants to deflect everything that he did after the death of his daughter, where he told lies and he panicked. That is a small portion of time in his life, and they want to deflect that away and concentrate on his lack of record, on his remorse, on his, when you hear the word, orphanage, he brought the girl in from an orphanage, and they really want to humanize the defendant and use less legal terminology and technicalities.
I think they're going to have a tough time doing that, to be honest with you. They had another kid, we're going to learn. That kid was treated very well, the adopted kid not. It's a scenario we've seen play out before, whether it's a stepchild or an adopted child. It's never really good for the parent in those scenarios. And we're going to learn this more as it unfolds. We're going to get back into that courtroom. As you can see, they've got the first witness on the stand, but we're going to take a quick break. We'll come right back to the Law and Crime Network. So this is Nikki Darafon. She is the speech therapist for little 3-year-old Sharon Mathews, in this case in Texas, against Wesley Mathews, the adopted father. Important information here as we're just getting into this case, which again is the penalty phase against this father who's pled to injury to a child by omission. There's this question about whether she would drink her milk and how she was being punished for not drinking her milk. Daniel Liebersohn is with me, trial attorney, so is Sanford Rubenstein. Let me start with you, Daniel. What do you think about, I mean, this is important, yes, but this jury's here just for the penalty phase. I mean, how much of this do they need to know?
Well, he pled guilty to an omission. An omission means he didn't do something. But what they're trying to show is that despite the fact that he pled guilty to something he didn't do, he he was very active in the death of this child. By showing that this child has never choked, for instance, it will be very easy for them to say, look, while he pled guilty to the omission, it's really, what really happened here is that he choked this child. He killed this child with his own 2 hands, despite the plea. So all this leads up to pointing him out as a real active participant in her death and not as a passive observer who just forgot to do something.
So the inference here is she didn't choke before, Dad got involved, now what do you know? So Sanford, tell me, what else would this jury really need to know? I think there can be the problem with going too deep into some of this stuff, but what do you think they really got to know?
Well, I think it's not only what they need to know, but also what the prosecutors want them to know, that this was an adorable little 3-year-old girl who's no longer with us. And part of this is laying that foundation to the jury to see it's a little 3-year-old girl.
Yeah, and it's important to note, too, she was from India. There was some earlier discussion about her speech abilities and sounded like a sharp little girl. She picked up everything she needed in a 3 or 4 month period with his speech therapist. So, in 3 years, gone. Just this little girl disappeared, and her dad put her in a trash bag, threw her away like garbage, and they didn't find her body for 3 weeks, made it difficult to find out what the actual cause of death was. We're going to come back to this case in Texas. Stay with us right here on the Law&Crime Network, right after this. And hello, folks. Thanks for joining us. We're in Texas for the Wesley Mathews case. This is the case against the gentleman, the adopted father, who has pled to the charge of injury to child by omission. I think we can change the name from injury to death, guys, because that's what happened here. I'm with Daniel Liebersohn and Sanford Rubenstein. Guys, let me start with you, Sanford. How important is it for this jury to understand that this little girl wasn't, spanked to death? They need to know the operative facts that got to death. How do we play that out when the ME can't even tell us what the cause of death was?
Well, I think the prosecutors have to be very clever. And then when they send a message to this jury, this wasn't simply the failure to call medical attention to aid this child, that this defendant did something to cause the death of this child. And somehow they're going to have to do that, given the fact that the plea that was taken in this case was simply to, the plea actually is injury as a result of omission, not even death as a result of omission.
I added death. I changed
You added
it. Yes,
death, but the truth of the matter is that's the charge, injury as a result of omission. So the bottom line is these prosecutors have to be very clever in their strategic handling of getting a message to this jury that he really killed her.
Dan, let me ask you this. I could see a backfiring here where the jury hears the details, they hear the charge to which he's pled, which sounds kind of mamby-pamby, doesn't sound like a big, serious thing. And they could say, look, how's he getting off so easy? We're going to stick it to him and give him the greatest penalty we can give him.
I think that's the challenge of the defense lawyers, and I think their biggest challenge here is specifically what happened after the crime. I think that all the actions taken by now the convicted person point to someone who was really involved in this case. And if I was a defense lawyer on this case, I would want to just isolate that all his actions that he did as someone who was panicked, who was someone who was distraught, who someone really had lost his mind after neglecting to give proper care. It is possible to make a big mistake and compound it with other mistakes. We all do that in our lives, but it doesn't make him guilty of actually causing her with his own 2 hands and making it seem worse than the plea. So that really is the challenge of the defense lawyers, to humanize this individual and to downplay all the terrible mistakes he made, which is something that the defense lawyer already talked about.
And if I may, and then the challenge of the prosecution is to somehow have this jury understand that this was a murder, really.
And that's the point, Sanford. You're exactly right, because, again, if they learn of the charge or they really care about the nuances, it does not sound like a big deal. Isn't it difficult for them to explain, the defense to explain away the fact that he put his little girl, no matter how she died, giving him the benefit of the doubt, in a trash bag? Once again, trash bags getting a bad rap here. They do have a purpose other than putting bodies in them. They put her in the trash bag, they throw her in the back of the car, and then he goes and tosses her out. And for 3 weeks, he doesn't say anything except for vacillating stories about, what happened that day. And then they find the body, and it's really to his benefit because they can't really tell how she died now. How does the jury put that aside and not hold it against him?
Well, if anything, I think this is where the cover-up is evidence of the crime. This attempt to cover up what really happened here is going to be damning for the defense, and the prosecution has to use that.
Okay. We have another witness, or we're getting, looks like we're getting a new witness on the stand here. Again, we're in Texas with, versus Wesley Mathews in the death of his 3-year-old adopted girl. This is a penalty phase. Let's go into the court. We are back. Welcome to the Law and Crime Network, everybody. I'm Michael Bryant. I see an empty witness chair there, it looks like. Yes, the witness we just heard from, Amber Nevin, worked with little Sharon Mathews for a few months, and the cross-exam of this witness pretty tight, pretty clean. Didn't have a whole lot to get into there. I'm joined in the studio with my two guests, Daniel Liebersohn and Sanford Rubenstein. Sanford, let me ask you, when you're cross-examining a witness like this, one that seems to have some foundational information, maybe not the smoking gun, what's your tact on that?
The first rule, use a butter knife, not a steak knife. And try to get out what you want to get out very smooth, but let the message go to the jury.
Okay. Dan, anything to add to that?
No.
Any utensils? Any other analogies?
No, although I am thinking about dinner now. But
steak knife, yes. Okay.
Yes.
Okay. So we're waiting for the next witness to come on board. They're lining somebody up. Okay, let's go back into the courtroom there in Texas. So there's Lindsay Walker. She is yet another physical therapist that was helping little 3-year-old Sharon Mathews with some developmental issues. She was such a tiny little thing from everything we've seen and heard about this little girl. And so these therapists were just giving her a little help in developing just normal skills. What I think's interesting, and my guest, I want to ask you guys this question now because it's going to play huge, I think, in the minds of the jury. Let me start with you, Dan. We know, this jury hasn't heard this yet, I'm confident they will, that this little girl suffered broken bones, arm and leg, for which the parents never sought any medical treatment of any kind. So now the jury's hearing she's a challenged child in the sense of her physical ailments, and they're going to hear that they never treated her for broken bones. They got to hold it against Dad.
It's very interesting. All these witnesses are coming forward, and these aren't even her parents. These are just hired professionals who are taking such care and concern with this little girl. And you counterpose that with the gentleman at the defense table who is her very father who did nothing. So all these broken bones, on one hand, it may go to show him as a monster who might have had a hand in this, but if nothing else, he is more than just a non-concerned parent. He has dropped the ball in every way, shape, or form, and it will be very difficult for the defense to come forward and talk about accountability, talk about remorse with all these factors, especially these wonderful witnesses that are coming in.
Real quickly, Sanford, agree with that? Is it going to be difficult?
I agree, but let me add something to that. But now you see a clever prosecution. First witness throws in there, oh, she was a little doll. Now this witness, oh, when she smiled. So now you have a jury, a mental picture of a little doll smiling, and this is the girl that died here.
Yeah, it is. It's heartbreaking. It is heartbreaking. We're going to get back into that courtroom in just a few minutes here. This is Texas versus Wesley Mathews on the Law and Crime Network. Don't go anywhere. We'll be right back.